an appeal in the matter of Borough of Hillingdon and Secretary of State for Transport and others.
Yes, Mr. Hall-Williams.
May it please you, my lords. I appear on behalf of Hillingdon Borough Council with Melissa Murphy of Council, on behalf of the Secretaries of State, Mr. Tim Mould of Queen's Counsel, and on behalf of HS2, David Elvin of Queen's Counsel and Michael Fry. The only matters, I believe, by way of preliminaries are to ensure that your lordships have improved copies of the document known as the written statement for information, which I understand being provided separately to you because the original version was not so clear.
I don't have that, I'm afraid. It's the first I've heard of it.
My lord, I've just handed up.
Yeah.
There's a white file.
Oh, right.
There are two documents in there. One is the written statement, which we thought was murky at best, and then in a tab behind it is the TfL report that's referred to.
Okay.
Again, because it's got a lot of plans in colour, we thought it was better for you to see them that way.
You've got that, John? Yes, we all have that, Mr. Hall-Williams.
Thank you. There is also at tab 3 of the supplementary bundle a plan showing the routes. Certainly in my copy, it's not very clear. If your lordships would like a...
Just take what that else?
Tab 3 in the supplementary bundle.
Yes, I think if we could have a clearer or colour copy, preferably, that would help us.
I understand that Selvin's clients can provide a colour copy.
Thank you.
You're seeking appropriate costs in due course, reproducing the appellant's bundle.
Well, very kindly, I think we offered, but HS2 said they prefer to do it
Thank you very much.
the original version.
Thank you.
Makes sense.
We're very grateful.
My lords, I will be in large part following the order of our permission skeleton,
Yes.
making some reference to our supplementary skeleton argument.
Yes.
And I'd like first to turn to ground 1A, and your lordships will appreciate that there is a link between A, B, C in particular, and the essence of the point is the misunderstanding, we say, of the import and the important principles established by the Court of Appeal in the case that we shall refer to as Hillingdon 1. Hillingdon 1 in the Court of Appeal, that is.
Yeah.
So the first ground, 1A, set out more fully in the permission skeleton, but in short is that the inspector wrongly considered that paragraph 6 of Schedule 17 imposes a legal burden standard of proof. My lords, I have 5 broad submissions to make in relation to this ground.
Yeah.
First, it is agreed between the parties in this court that the inspector would have been wrong to have interpreted paragraph 6 as imposing a legal burden of proof. Neither the respondent nor the interested party argues otherwise. Indeed, the judge, it's clear from the judgment, also accepted this to be the case. The second submission is that that common ground reflects the correct position having regard to the statutory words themselves.
Yeah.
Your lordships will have looked at paragraph 6 of Schedule 17, tab 1 in the authorities bundle.
Do you want us to get that out to look at?
I think it would be helpful to have this to hand, near to hand, on a number of occasions during my submissions.
Yes.
And if your lordships have paragraph 6,
Yes.
and it's subparagraph 5,
Yeah.
which is the particularly relevant one, and subparagraph 6, in the context of a proposal for arrangements for lorry routes.
Yeah.
Paragraph 5, subparagraph 5, the relevant planning authority may only refuse to approve arrangements for the purposes of this paragraph on the ground that. So we know from the start that there is a specified set of grounds on which the local authority, should they wish, can refuse. The first, little a, is not relevant. The second is that the arrangements ought to be modified, and it's little 2 with which we're concerned, to prevent or reduce prejudicial effects on road safety or on the free flow of traffic in the local area. Looking ahead to subparagraph 6, that's a restriction on the local planning authority's power to impose conditions, and they are limited to the ground referred to in subparagraph 5b, to which I've just referred. So even in the context of conditions, the relevant grounds are those in 5b.
Yeah.
But the point that I make here is a simple one, and it's not in dispute, that this paragraph, whilst it sets out an important evaluative task for the authority to carry out, it does not impose a legal burden of proof.
Yeah.
Indeed, nor is there any suggestion in the Court of Appeal's judgment in Hillingdon 1 that such a legal burden is imposed on the authority. There is a sort of counter weight to that, of course, that what the Court of Appeal did is impose a duty on HS2 to provide the required information for that evaluative task. The third submission is that common ground reflects also the established position in relation to evaluative tasks in planning matters, such as are in play in subparagraph 5b, 2. It's well established in planning decisions that there is no legal burden of proof. Slightly different in enforcement cases, where in order to demonstrate immunity, there is a burden of proof imposed on an appellant. But in ordinary planning decisions, then there is no such legal burden of proof.
If there was no dispute about the adequacy of the information, would it not then be incumbent on the relevant planning authority to demonstrate from the information about which there is no dispute as to adequacy that the requirements of paragraph 6.5 were met?
So if there was no dispute that there was sufficient information,
If there's no dispute about the adequacy of the information,
there's no legal burden in that context. In any context, there is no legal burden imposed by this statute. And indeed, I don't believe it to be urged upon the court that there is. So far as this third point is concerned, it's a slightly wider point to say that there's nothing derived from planning cases that imposes a legal burden. That's the thrust of the third point. Indeed, you may say it's not necessary where the statute doesn't expressly or impliedly impose such a burden, but it is there, and again, it's common ground between the parties. Now that, my lords, is a recognition of the task here, which is actually akin to many planning judgments, where the relevant decision maker has to assess the issues with a free hand, with reference to available evidence from whatever source. It's also a reflection of the fact that the parties to the process, not just the local planning authority, but the appellant, indeed even third parties should there be in attendance, are all interested in the outcome. So they're all responsible, in one sense, for assisting the decision maker, in this case the inspector, to reach a decision. And here there's no reason why the local planning authority should bear any legal burden of proof. After all, it's HS2's request for approval, which it needs, by reference to paragraph 6, subparagraph 1, to have approved in this important step in the process. And indeed, one should therefore assume that when the application is made, the request is made, HS2 presumably make it on the basis that the proposed arrangements need not be modified. My Lord, the fourth submission that I make in ground 1A is that reference to paragraph 55 of the framework to which Mr. Mould refers, paragraph 22 little a of his skeleton argument, does not affect this position. Not merely because it's policy, not law, but actually because its terms do not impose any legal burden, nor indeed any policy burden. That paragraph merely advises the decision maker that as a matter of policy, conditions should only be imposed where they are necessary, relevant to planning and to the development to be permitted, enforceable, precise and reasonable. There's nothing here imposing any such burden, as we say, was imposed by the inspector. Whether or not a condition meets policy requirements would be for the decision maker's judgment and for each party to argue about, depending upon their different perspectives. And your lordships will perhaps also make a note that in any event, paragraph 55 did not affect the inspector's consideration of issue 1 as defined by him in the decision letter. The fifth and last submission under ground 1A is what I understand to be where the major issue lies between the parties. It's our strong submission that the judge's view that notwithstanding the language used by the inspector, which he picked up upon and noted, he was not, according to the judge, imposing a legal burden or standard of proof. He was merely making a point about what the evidence shows or does not show. With respect to the learned judge, that is not, we say, the correct reading of the inspector's decision letter. On the contrary, read fairly and taken as a whole, the decision letter shows that the inspector was not merely making a point about the evidence, but in terms imposing a burden of proof, one which governed his conclusions on the evidence and dictated his overall conclusions. To put another way, contrary to what the learned judge concluded, this is not a case where the inspector in one place used inapt language but didn't mean what he said. This is a case where the language used throughout the decision letter, used on numerous occasions, shows clearly what his reasoning was. my Lords, our permission skeleton argument provides the relevant references, but it is important, I think, now to turn to the decision letter to seek to support my submissions on this point. And the first paragraph, and a rather critical one, you might think, bearing in mind it is at the very start, and it sets out the central test. So one immediately knows that what follows, what he defines as the central test, is going to govern the rest of the decision letter. So in the fifth line, the central test, in respect of the main issues in the appeal, is whether or not the Council has produced sufficient evidence to substantiate its concerns with regard to the alleged prejudicial effects on the free flow of traffic and highway safety. Pausing there, it's clear that that is the driving force for his decision. Later on in the decision letter, we find where it comes from and the way in which he understood it to be. He sets up a test.
But if you look at 8, when he gets to that paragraph, it says what it says, and it comes between two sentences talking about whether or not he needs to make a site visit to assess himself the position. When you get to main issues, on one reading, you could say he's drawing a distinction between, one, whether the refusal is justified, and two, whether the Council has produced sufficient evidence to demonstrate a need for the proposed conditions.
I don't think it does, though. When it comes to look at the body of the decision letter, my Lord, that's not a distinction that can be borne out, because he imposes the burden of proof under issue 1.
Okay.
Look at the last sentence of paragraph 5, and keep that in mind, not only throughout this submission, but through later submissions. My own assessment of whether or not the highway network and specific junctions are busy or congested is not relevant to whether or not that test has been met. Now, one might think one has to look at that once or twice, but it does indicate that the inspector concluded that his role was not to assess baseline conditions. Indeed, he says, not relevant for him to look at. At a stroke, that puts into context the legal burden of proof and the influence it has on the decision. He's saying, not actually for me, it's up to you to demonstrate it as a legal requirement.
So if he'd said in that little sentence, the central test is whether there is sufficient evidence to substantiate the Council's concerns, would you have any complaint about that? If there is evidence to substantiate the Council's concerns.
I think if it was couched for the rest of the decision letter in a context where it was plain that he was carrying out the evaluation himself properly, taking regard fully and objectively of all the issues in paragraph 6, one might be inclined to accept that as a reasonable way forward, because plainly he has to have some evidence which assists him in that
it's the
evaluation.
It's whether the Council has produced
no, because
formula that you're concerned with.
I think it would still be a concern, my Lord, because he would there be looking only at one party to produce evidence which he needs to do to carry out his
The reality is HS2 put in the evidence, they've not consented to the conditions, they're not going to put any more. The question is whether the only ground, the only requirement is met on the evidence before the inspector. That's what he was doing, wasn't it?
Well, it wasn't what he was doing. What he was doing was saying, in accordance with the representations that were made to him by HS2, that all they have to do, HS2 that is provide what's in PFN 6, which we'll come to, which is nothing more than some rather generic reference to movements without any depth of information being set out, and then saying from here on, the legal burden, following the judgment of Mrs. Justice Lang, it's a legal burden on you. We don't have to do anything else. And they didn't.
Well, I mean, just thinking about what is involved practically, he has to make a decision on the evidence before him. And he has to decide substantive issues about highway capacity and safety, according to the Act. if the request is resisted by the authority, which is this case, then necessarily it will be the authority, at least in the vanguard, if not on its own, producing the evidence to substantiate the refusal of the request, won't it?
That might follow if the relevant sufficient evidence had been provided in the first place.
Well, I think that might be
That's the
that's a
point.
separate question, isn't it? I mean, at the moment we're just looking at
Yes.
the structure of the decision.
I think
making.
not. The
No?
purpose of my submissions, my primary submissions, is there should be no reference to one party bearing any legal burden to produce evidence. It cuts across the whole approach of the decision maker, which is, to borrow the words from the Court of Appeal, to look fully and objectively at the evidence available. There's no suggestion in the Court of Appeal's judgment that one party should bear any more of a burden than another party. And indeed, it's specifically the case in the context of Schedule 17.
Yes, but what I'm trying to do is to detach ourselves, if we can, from the language of burden of proof and just look at the practicalities of a decision like this. If the authority resists the request, it will be producing evidence, or it will be pointing to evidence that substantiates its resistance or refusal. That's just the nature of things. And the inspector will, if he's doing his job, weigh that evidence, assuming there is enough of it for his purposes, and reach a view. That's what happens.
Yes,
Now, if one removes the language of burden of proof from the picture altogether, that's what in fact happens. So might one ask here, well, how then was this inspector's approach any different, really, as a result of the language that he's used?
I think his whole approach would have been different. He has been, with great respect to the inspector, he has latched on and relied upon this burden of proof as his central test. It governs the whole of his decision-making thinking.
But I mean, are you able to point to passages in the decision letter where you can make good the assertion that his whole approach would have been different?
Yeah, and the first one is paragraph 5, my Lord, and the next is paragraphs 17 to 18. And one should note here the approach. So we've got words, the central test. We've now got a heading, what is the correct approach? The first thing we note from paragraph 17 is the reliance on the High Court judgment. There's no dispute between the parties that this decision relied upon Hillingdon 1 in the High Court. And so we can see from that paragraph and from paragraph 18 that the central test, to which I've already referred, and the burden of proof that is imposed by the inspector derives from, this is Justice Lang's judgment, paragraphs 80 to 81 in her judgment in the authorities bundle, and also HS2's arguments in the written statement. And when your lordships look to the written statement and to Mrs. Justice Lang's decision, one can see why the inspector has put it at the very top of his approach. He has treated it, because it derives from case law, as a matter of law, imposing a legal onus on the authority. Would your lordships like me to take the court to HS2's argument or to Mrs. Justice Lang's, or does your lordship have it in mind?
I don't think it's necessary for my part. No, we don't require that.
The references are in the permission statement skeleton. And what's quite clear, I mean, there can't be any doubt about it, especially from the response document from HS2 is that in section 1 in particular, there is text headed, the legal test, and everything that follows is setting up this burden of proof. It's called a burden of proof. Indeed, the inspector calls it a burden of proof.
The difficulty that I've got is this. If you go back to the facts of Hillingdon 1, that becomes critical because the authority had nothing other than various things that had been done before. It didn't have a survey. And the burden of proof becomes critical because if you phrase the question in terms of who bears the burden of proof, the authority would be bound to lose in Hillingdon 1 and did lose in Hillingdon 1. In this case, even if you use the language of burden of proof, but you get on to the next question, the inspector must decide whether the arrangements ought to be modified, but only on the ground about prejudice to traffic. There was evidence, much of it produced by the council and its reasons. You had the environmental statement, you had the traffic for London document, and you had the latest figures. What you didn't have, you say, was an actual specific assessment of the peak hours and the number of lorry movements in the peak hours. But once you get beyond the, he shouldn't have said this, and if the information is adequate, thereafter, isn't it just forensic rather than...
No. I'd make 2 points, my lord. The first is that Hillingdon 1 should not be distinguished in the way that your lordship has picked up from the learned friend skeletons. It's not a case that there was no information in Hillingdon 1. Hillingdon 1 was a case on which it was accepted that the evidence was not adequate. That's quite different. Mr. Justice Ouseley says at one point in his judgment there was no information. That's not correct. Your lordships will remember that there was information compliant with PFN, the relevant planning forum note in Hillingdon 1, so they had that information. They also knew it was an area of archaeological importance, which all that implies as to the likelihood of some valuable archaeological remains and the need for further evaluation. And they didn't have anything to go on to judge the impact in order to arrive at the conclusion whether or not it needed mitigating. This case is no different. It's no different at all. In this case, we have a situation where it is agreed that the network is congested. That can be paired, if you like, with the recognition of the site of archaeological importance. In other words, where there is plainly a possibility, if not a likelihood, of some harm from the addition of a large number of lorry goods vehicles. And what the authority doesn't have, in exactly the same vein, is any assessment of what is proposed in terms of the figures at critical hours, but importantly, not just the figures, but how they mesh together to form an impact statement which will enable the authority in the first place and the inspector in the second place to carry out the whole of the task in paragraph 6. Remember, my lord, paragraph 6 is not a simple question of is there prejudice. One can read the judgment and at times think that's the only test. That's the only thing that has to be satisfied. It's not. There is quite a complex arrangement of elements that go together which are required to be considered for a proper evaluation under paragraph 6. In order to reach a view as to whether or not the arrangements ought or ought not to be modified, one has to look at a number of things. First of all, the baseline. We shall see that when the inspector considers that, the only thing he does is say, I haven't got that evidence that I can rely on which shows necessarily that that's the baseline, in the context where he says it's not relevant. The second thing he doesn't have is what is actually proposed in terms of traffic movements, other than a notional daily figure. Well, then he has to stand back and think 550, 480, it doesn't matter which figure it is, vehicles in a day in a relatively circumscribed local area in a busy network to reach the rather obvious conclusion, well, hold on. We need to understand how many are coming through in the critical peak hours and how they relate to the junctions and the base flow and the turning movements. And that's what we say is missing. That's the first point. So sorry, I've rather laboured that. But the second point, it wouldn't really matter to this ground, my lord, whether there's a distinction with Hillingdon 1. This ground, 1A, depends upon the driving force of the wrong approach, the imposition of a legal burden which shouldn't be there. And once, it'd be like a judge saying, well, I'm going to put a legal burden today, not on prosecution, but on the defendant. That's how important a legal burden of proof is, and that's why it drives the rest of the decision. So, for example, when we get to the paragraph 34, and we're still in issue 1, and that's the issue about refusal on the basis of modification rather than the imposition of conditions. With reference to the High Court judgment again, this is Justice Lang's judgment, paragraph 6 requires, so we know he's relying on the statute for what comes next, approval should only be refused where there's clear evidence that the proposed arrangement would result in prejudicial effects on road safety. Well, apart from the fact that cuts right back the whole of his task under paragraph 5, it's not just about demonstration of prejudice, there's a bigger evaluation task. The next sentence, the burden of proof falls on the council to demonstrate that the proposed arrangements would be so prejudicial. So we know from this critical paragraph that the burden of proof derives from his understanding of the law, and we know that it's governing his decision. And we know that the test, the central test, is that legal burden of proof satisfied?
Do you, leaving aside the words burden of proof, on which you understandably lay emphasis for the purposes of your submissions, leaving that to one side here, what about the formulation so prejudicial as to require that the Schedule 17 submission should be modified? Is that offensive in itself?
Well, I think it does, because in the context of what else he says, he's not carrying out fully and objectively, according to Hillingdon 1 Court of Appeal, the evaluation task that he needed to, which was not simply to come to a view about prejudice, but to ask whether or not it was appropriate for a modification to the arrangements.
Yes, but I mean, what I'm getting at is if you like, what you might describe, to fit your argument, I imagine, the standard of proof. Do you take issue with that formulation, so prejudicial as to require that the submission should be modified?
Yes, I think taking with the next paragraph, Lord, which makes it sort of worse, if you like, but the would be so prejudicial, it is, quite honestly, it's taking it a step further. It's not only saying to the council, you've got a legal burden of proof, I'm not really interested in looking at this myself. He's then saying, and not only have you got the legal burden of proof, but you've got to show me to a certain level.
But isn't that implicit in paragraph 6? You start off, you've got the development, it's got planning permission. This deals with the arrangements with respect to roads. Then you get to 5, and you can only refuse to approve the arrangements, where the arrangements ought to be modified to prevent or reduce prejudicial effects. It's not a freestanding slate. Is there prejudicial effects? Oh, we don't like those. It's, you've got a planning permission, you've got to get approval so far as the road arrangements are concerned, and you should only depart from that. The arrangements ought only to be modified to prevent or reduce prejudicial effects. So isn't it implicit that there's some sort of standard in the ought to be modified and the context?
No, indeed,
No.
Neither of my learned friends suggest that. That's not the way the case is put. They don't suggest that there's any implicit burden in the paragraph. That would cut, if I may say so, my Lord, right through the statute.
Not implicit burden, it's what's being looked at. Not should I grant planning permission for this because of the roads. It's planning permission has been granted. Ought I to modify the arrangements that follow from that because of the prejudicial effect. It's having within it a context that it's not just will there be prejudicial effects, but are the prejudicial effects of such a nature that they ought to lead me to modify the arrangements if that's possible.
That's rather my point, at least, my lord, until you got to the point at such a level, which immediately starts to set some sort of standard that's not in paragraph 6.
Right, okay.
It's a straightforward question. The inspector has to decide whether there ought to be a modification to the arrangement put before him. But he's got to look at everything which relates to prejudice. And importantly, he's got to feel open to a free hand, as I put it before, looking at the evidence to evaluate on the evidence, like any planning decision, the likelihood of harm.
Even if the harm was less than that anticipated at the time the permission was granted, there is less harm. Nonetheless, they must go and decide whether or not even that amount of harm.
And that was actually fundamental to Parliament's approval.
That's what you say. You say that the Schedule 17 process is quite separate and added on, and it must meet both the statutory process and also the paragraph 17.
Absolutely right. It's actually fundamental, my lord, that when Parliament gave its approval to HS2, it did so on the basis that certain matters would be for the control of local authorities, and this is one.
And what is to be controlled is the level of road usage to see if it's prejudicial.
Those matters set out in paragraph 6, Lord, that's correct.
Do you accept the first sentence of paragraph 34 as accurate or not? You challenge the second sentence.
Yes, I do, because...
Sorry, I can't remember which way around I... Do you accept it or do you...
we challenge it.
What do you challenge?
We challenge it because it is related to the next part. One can't divide them. When he is applying his burden of proof, as we shall see from what follows.
Well, no, just a moment.
Yeah.
If we ignore, before we get to the second
Yes.
sentence, is the first sentence an accurate précis of what paragraph 6, subparagraph 5 requires?
Well, it doesn't require that.
What's wrong with it?
Because paragraph 6 doesn't make any reference to the clarity of evidence or the standard of evidence. That is a matter for the decision
But you
maker
can
at large.
only refuse, surely.
All that's happening, my lord, all that's happening when you refer to the phrase only is a restriction on the grounds.
Yes.
The grounds relate to...
But doesn't that mean you must have evidence to show that the ground applies?
well, the grounds must apply, but by reference to the planning interest set out in little b Roman 2. The question of whether they ought to be modified is not part of the ground as such in that way. It's not a limitation which implies that there should be a burden imposed.
Are you saying the authority would be entitled to refuse to approve arrangements if the evidence was unclear?
No, I'm just saying that that's not. I'm just well, not as I'm saying that he wouldn't be entitled to. It's a matter of planning judgment. That would be perverse, but it doesn't derive as a proposition from paragraph 6.
So it's the words clear that you don't like?
That is correct. He obviously has to rely on evidence.
Well, it's the words clear and so in paragraph 34 that you don't
Exactly.
like.
One can't separate
So
these.
if you somehow manage to subtract clear and so, you've still got your point about burden of proof, but when it comes to, as it were, standard of proof, it's clear and so that cause offence.
Militate. And one can see the way that that's been applied in later passages. So, for example, at 44, when...
Before you go to 44, what about 35? If we were to strike out the council must demonstrate with appropriate evidence, and if it read, it must be shown with appropriate evidence, that, would you agree with A, B, with 1, 2 and 3?
Yes, because Roman 1 again imposes a standard which is not within paragraph 6. What's happening here is the inspector is taking this as some legal mechanism which has to be satisfied. That legal mechanism does not exist. It's a holistic planning judgment that has to be made here, subject to public health principles, of course, but there's no legal burden of proof imposed by paragraphs.
No, this is not about burden. It's about burden was the
Standard.
council must demonstrate, and I've changed those words. So we must focus on 35.1. And the issue there is not burden in 35.1 and ignore the 3 lines at the beginning. The use of the proposed routes would rather than might lead. Is that wrong?
I think it is, because it tells the reader that what the inspector is asking for is something, which I said in the High Court's akin to a criminal standard of proof. In other words, some certainty.
Yeah.
Why should the arrangements be modified? How does it follow that they ought to be modified if they only might lead to the alleged prejudicial effect?
Because
So the words ought in the paragraph, that paragraph 5b, surely consistent with would rather than might on 35.1, aren't they? Or are you saying that arrangements ought to be modified if they might lead to the alleged prejudicial
that's right.
effect?
What the inspector has to look at is the questioning of prejudice. And that can amount to the risk, the likelihood, all of which has to be balanced. And the words used by the inspector in context, to take your point, I hope directly as I can, in context, indicate that the inspector was not only imposing a legal burden of proof.
No, it's not legal burden.
I know, and
that's
what I'm
not the
trying to
answer
do.
to this. Repeating legal burden repeatedly to any question doesn't help. This is a question of forget legal burden,
I've got the point.
forget all of that. I'm the inspector sitting here. My state of mind is, having looked at everything that everyone has said, it might lead to prejudicial effects, but I'm not satisfied that it would. Is that acceptable?
That's acceptable. If he reaches the conclusion that there would be no prejudicial effects.
So it's
And
turned
that is-
around. He ought to modify the arrangements unless he's satisfied that there would be no prejudicial effects. We're just not clear. The argument is about would or might. It's about the level of interference that must exist in order to make it appropriate that it ought to be modified.
I think, my Lords, I do understand your Lordship's point.
Yeah, well, what's the answer to it then?
Well, I'm trying my best to
Yeah.
answer, if you just bear with me. What I'm saying is that the expression would rather than might indicates in context that the inspector is treating the standard of proof as deriving from paragraph, Schedule 17. So he's imposing a standard of evidence that has to be met.
I'll have one last try. If you forget the words of 35 completely for the moment, and you look at paragraph 5b2, does an inspector have to decide that the arrangements ought to be modified because they would prejudice road safety or the free flow of traffic, or may he decide that the arrangements ought to be modified because the arrangements might prejudice road traffic or road safety?
I think I mean, the difficulty here is the words would and might are not used, but my submission in answer to your Lordship is that the text indicates that the question is whether the arrangements ought to be modified if there are prejudicial effects which the inspector considers should be prevented or reduced.
Your key point is this isn't all about the whole language of burden and standard of proof is the wrong language, because would it be fair to say this is about risk?
I think that's the approach leaves risk out. The inspector doesn't make.
So would yeah, that's your point.
Yeah.
The ought to be modified to prevent or reduce prejudicial effects is more consistent with the language of risk rather than the language of
It includes that element of risk.
risk of significant harm.
Hmm?
No, I'm just an echo from somewhere else in my legal background, Mr.
Well, yes. I mean, I'm beginning to wonder whether what the inspector has to do is to work out to his own satisfaction whether this number, the likely number of lorries in the peak hour, is going to upset the capacity or safety of the road network. I mean, is it really more complicated than
No,
that?
it only becomes, well, if not complicated, certainly wrong, if the inspector sets a legal burden and sets a standard of evidence as a matter of law. Those two matters, we say, are wrong. Perfectly within his judgment, subject to public law principles, to take a view on the evidence and reach a view, so long as he's taken into account all material considerations and so on. What he's not entitled to do is start the exercise and allow his evaluation such that it is to be governed by a legal burden of proof, accompanied by, associated with, and bound up with what appears, if I may say so, to be an undue standard of proof that doesn't come from Schedule 17.
So it's wrong to adopt a, quotes, legal burden of proof, and wrong to impose too high a standard of proof.
That's correct.
And that's it.
That's it. And what the learned judge does is as you would have seen in a number of paragraphs, says he accepts that the language used by the inspector was not doing what I said should not be done, in other words, imposing the wrong legal test, but he said was merely making a point about what the evidence shows or doesn't show. Well, with great respect to the judge, bearing in mind the central test, bearing in mind under the heading what my approach is, bear in mind the reference to the High Court judge, it's clear that he's imposing a legal burden of proof, and he does it throughout the report. Every bit of evidence that comes before him, he says, this doesn't meet the burden. This doesn't meet the burden.
And he says it at the end.
And he says it at the end. His whole approach is governed by this. And what it also leads to is a sort of consequential problem, is that he doesn't make any findings himself.
What he does find is that the number of lorries are likely to be less than the original estimate, less than the TfL. He doesn't know the number of lorries during the exact number of lorries predicted during the peak hours, and he's saying to himself, well, I take into account the fact they've got planning permission. I know there's an additional paragraph 6 exercise, but given that these levels are likely to be less, and given that there were sufficient arrangements in place for an anticipated higher number, on the whole, the arrangements ought not to be modified to reduce.
He does, and
That's
what your lordship...
That's not right, is it?
It's not at all right, no. But what your lordship is pointing to is matters that I'm coming to under rather discrete grounds. I know it's somewhat artificial because his whole reasoning, we say, is based not only on the wrong legal test, but actually, when we come to, I think it's ground 1D, he misunderstands Parliament's intention. He seems to suggest exactly what your lordship is referring to, which is, well, I've got to remember Parliament found these impacts acceptable.
Well, that's exactly, yes. You almost say there are two separate things. There's the parliamentary approval, which is one thing, and you treat the paragraph 6 as almost completely separate. This is how they would decide a planning permission application generally. And I'm asking whether or not they shouldn't be read together, that the Schedule 17 exercise is consequent upon and must have regard to what has gone on before, otherwise there's no point in getting the parliamentary approval.
Of course, when approaching the Schedule 17 question, indeed it's, I think it's within the statutory guidance there's reference to the environmental statement which Parliament took into account, but expressed within the statutory framework, this is made clear by the Court of Appeal, is a recognition that when Parliament made its decision, it did so on the basis that some matters would
which
be left
be considered by the Council,
control.
yes. And my question is, and does that mean they have to ignore completely the parliamentary context and approval?
No, not ignore completely, but the question then becomes whether or not the inspector has properly understood Parliament's intention and the process, or whether he's actually said, well, listen, I shouldn't really be bothered because there's something going on under the environmental, the EMR, so-called, which is all for HS2 to lead, and I've got to remember that Parliament approved the bill on the basis of the environmental statement. Well, actually, that's not quite how it happened. Parliament approved the bill on the basis that paragraph 6 of Schedule 17 would provide the opportunity to reduce and mitigate the impacts.
Right. Now, this is ground 1A. How are we getting on?
Not
I
very
do
well.
appreciate, of course, that we've asked you a great many questions. But is it time, do you think, to move on to another ground?
I'm happy if unless I can help getting further with that.
Well, I
What
think
I
we've
would
explored
ask-
it quite fully.
Yeah, what I'd ask your lordships to do is, of course, to, in the context of the submissions that I've made, read the remainder of the decision letter and pick up all the paragraphs where this burden is imposed. It governs everything.
Well, that's all in the skeleton argument, I think.
It's the relevant
Yeah.
paragraphs are referred to.
All right. So are we going to ground 1B?
Ground 1B.
Thank you.
Lord, I think there are 7 submissions to make here. The short point, set out more fully in our permission skeleton argument, is that the inspector wrongly considered that paragraph 6 of Schedule 17 requires the decision maker to grant approval for the arrangements where there is inadequate substantive information as to the impact of those arrangements. So I think there are 7 broad submissions that I wish to make, so your lordship's going to feel the progress that I'm making.
Okay.
The first is this:
Pace ourselves.
the nature of the task under paragraph 6 of Schedule 17 is an evaluative one. I don't need to say much more about that on the basis that I've already laboured that point. It's not just a question of prejudice, it's a bigger question. Your lordships may make a note to paragraph 26 and 27 and 72 of the Court of Appeal's judgment, which make a similar point about the scope of the relevant paragraph in that case. It's an evaluative task taking into account a number of elements. The second submission I make is this: that the Court of Appeal in Hillingdon 1 established that HS2 is required by statute to furnish adequate information necessary for the statutory task to be carried out. The specific references there from the judgment of paragraphs 70 and 77 to 78. I don't believe that's a proposition that is in dispute. But it's important to understand the rationale, the reasoning of how the Court of Appeal got to that point. Because here, of course, what the Court of Appeal did is impose a duty on one party. The statutory scheme is bespoke. It's not to be equated with any other scheme. It is based on duties of close cooperation between the parties, contemplated to take place before the deposit stage. 2 particular duties are at stake here. One, the authority's duty to carry out the relevant evaluation fully and objectively, but also that HS2 has no right to submit inadequate information for that purpose. On the contrary, it has a duty to provide adequate information, in particular paragraph 77. So the duty, is important to emphasise, was not simply to provide some information, but the information that was provided needed to be adequate for the evaluation task, which I've indicated is not a simple single element question. And in this case, the critical short way I put it is it has to have some impact assessment. And in particular, at paragraph 78, the Court recognises that there might be some debate as to what's adequate, but the underlying point, that last sentence is critical, that the request as deposited should be adequate to meet the statutory task.
That's para 78 of
That's
Hillingdon
correct. That's correct.
1. Right.
So the third submission that I make under this heading is that Hillingdon 1, the Court of Appeal, also established that if HS2 fails in its duty to provide adequate information at the deposit stage, the authority cannot, I suppose by definition, because the information is inadequate, carry out its duty. Secondly, it's under no obligation to process the request, and what it should do is to decline to do so. Again, paragraphs 70, 78 and 79. The fourth submission under this heading is this. The basic principle, that basic principle, is not altered in this case simply because the matter was on appeal. This case is one in which, because of the timing of it, the process did not follow what the Court of Appeal envisaged in Hillingdon 1. So our ground 1B takes as its starting point a decision maker on appeal rather than at deposit stage. But it's clear from the Court of Appeal's judgment, we say, that the key principle of the provision of adequate information does not change simply because the matter is on appeal.
But if the inspector thinks he's got adequate information,
I beg your pardon, my lord.
if the inspector thinks he's got adequate information, even though your client didn't, can't he proceed?
If the inspector thinks he had adequate information, but as a matter of law, that's not correct.
Right. There's a legal standard, yeah.
Exactly. So a failure by HS2 to comply with its duty remains relevant at the appeal stage. The inspector has the same request in front of him. He's seized of it now and he has to determine it in the same way. His powers are coextensive with those of the authority. And one has to remember that, of course, in Hillingdon 1, that was also a case where the Court of Appeal quashed the Secretary of State's decision on the basis that HS2 had not supplied adequate information, and because of the Secretary of State's approach to that matter on appeal.
Can we just stand back for a second? And just returning for a moment to your exchange with my lord. If to pursue my lord's point, the inspector, I'll put it this way, manifestly regarded the information before him as adequate to his task, but the authority maintained otherwise on a challenge to this court, or to the first instance court. What is the test? Is it a Wednesbury test, or is it some other test? Bearing in mind that the decision maker is the inspector. What is the test for the court's consideration of the argument put forward by an authority that says, well, the inspector manifestly did think that he had enough information, but we say he didn't?
Yeah, that's what ground 1B is about. The rationality test is ground 3, as an alternative. This ground is based upon our submission that there is a legal hard-edge question for the court to be seized of.
Right,
question of adequacy.
Yeah, well, so that it's really the articulation of that hard-edged question that I'm after.
It's the next broad submission that I had, my Lord.
Right.
Can I just, before I articulate it, can I just make just one further point?
Yep.
Is that the essential principle from the Court of Appeal's judgment is that absent adequate information, which HS2 was duty-bound to provide, the inspector was not able to carry out his task. Okay? That's important to have in mind. The articulation of the point is this, and our submission is whether or not the evidence was adequate for the statutory task to be carried out is a question of law for the court to determine. And
But on what test or basis?
we say that that is based upon the Court of Appeal's judgment, paragraphs 70, 77 and 78. And in
Yes, but
particular,
how do we decide it? It's a question of law. Right. I move on to the next part of the exam question. How do I decide whether it's met or not?
it's one, the court has to look at the evidence and determine whether or not, as a matter of law, that evidence is adequate.
Yes,
in
but
order
what we're after is the legal test. That's what my lord is driving at.
That's what I'm trying to articulate, albeit perhaps
So
slowly.
how do you formulate the legal test?
The question is whether or not the evidence was adequate for the statutory task to be carried out. That would say it's a question of law. And we say that that does derive from the Court of Appeal's judgment, and in particular 70, 77 and 78. Of course, we've dealt with this in our skeletons as well. And we say that those paragraphs indicate that this is a hard-edged question of law. First,
Can the adequacy of evidence ever be a hard-edged question?
I think it can.
Isn't it a matter for... Why is it a matter for the decision maker to decide?
It's no different in one sense from the process in perhaps a criminal court, where a judge will have to determine the sufficiency of evidence to get through to the next stage of the prosecution.
Ah, so does that introduce a standard? That's the
Yeah.
standard you're introducing.
Yeah. It's a
Sufficient.
legal standard. That's exactly the point. And the whole point here is that the Court of Appeal was looking at this as a question of statutory interpretation. The Court of Appeal was not dealing with this on the basis of some rationality challenge. Wednesbury is not referred to. The Court of Appeal only has to look in particular to 77 and 78 at the last two sentences there, three sentences in 78. The scheme set up under Schedule 17 contemplates that a request will be submitted only when it contains adequate information. There may always be some leeway and room for debate as to what's adequate, and under the cooperative procedure which has been instituted, there will often be scope for discussion between HS2 and the authority as to what's required, and then this. But that doesn't alter the underlying point, which is that the request as deposited should be, quote, adequate. And that's the duty that the court imposed on HS2, a statutory duty. A statutory duty where the breach of which is, we say, quite properly, to be investigated by this court. It's a hard-edged question that admits of a correct answer.
The problem is a lot depends on what you decide you're going to do. If you're the inspector and you take the view, the question is, ought I to depart from the arrangements in a context where this has been approved, you might say, well, I have got enough because what's proposed will have lower traffic movements than the earlier assumptions. But you say, no, this is entirely freestanding and separate, and you cannot decide whether you ought to modify the arrangements with respect to the use of the roads about which nobody is complaining. You've got to go further than that. So in a sense, the real question is, what is the statutory task?
But that's exactly the point. The statutory task is set out in the paragraph and akin, similar to that which the Court of Appeal indicated. This is an evaluative task to be carried out, but it can only be carried out if there is, quote, adequate, end quote, information.
But if you're wrong on your other grounds in the sense that it is appropriate or it is permissible for an inspector to view the ought to modify the arrangements for the purposes stated, and in deciding that he can have regard to the context, the parliamentary context, the environmental statement, then we might reach a different answer as to adequacy,
Well,
as compared with if you had your preferred approach, which is that in effect the question of whether or not you should allow road movements is entirely freestanding and to be considered by you a afresh, if you like.
I readily accept that, of course, it's part and parcel of the inspector's duty to examine the evidence, but what the Court of Appeal, and reach a judgment, a planning judgment, but what we say is that in this particular statutory scheme, there has been imposed by statute, as understood by the Court of Appeal, to impose a statutory duty, not only on the authority, but on Hillingdon, on HS2, I beg your pardon. And the background to that, of course, is the peculiar nature of the process here, where the Court of Appeal has made it quite clear that this process survives, works on, depends upon a collaborative process in advance of the deposit stage, by which point the problems that arose in Hillingdon 1, and we say here, ought not to arise. But bearing in mind that collaborative process which Parliament intended, it's right that we should impose a duty on HS2 to provide enough information for the authority to carry out its task. That's what it did. And once it's done that, it becomes a hard-edged question of law. If I'm wrong, of course we rely on the rationality challenge. But if you want to stand back and ask how the Court of Appeal made its decision, as expressed in the judgment, it can hardly be denied that it didn't approach it on the basis of rationality. It didn't say that that there was any irrationality involved. It based it squarely on the failure of the statutory duty to be carried out.
What the court said, I recall, in paragraph 78, in that passage that you took us to, the end of the paragraph, among other things, was this: there may always be some leeway and room for debate as to what is adequate, and under the cooperative procedure to which you referred, which has been instituted, there will often be scope for discussion between HS2 Ltd and the authority as to what is required. But that does not alter the underlying point, which is that the request as deposited should be adequate to meet the statutory task to be performed by the authority. Yet the court there isn't referring to or seeking to articulate some hard-edged test beyond adequacy for which it contemplates room for debate, as it puts it.
Well, our submission is that, in particular, that last sentence and the highlighting of the word adequacy and the moving away from the leeway for debate about what's adequate is that emphasis, but the hard point remains that as part of the statutory duty, what you've got to remember is that the adequate information comes within the statutory duty. It's bound within the duty on HS2 to provide adequate information. So in order to determine whether that duty has been breached or complied with, one has to examine as a question of law whether or not the information is adequate.
Right.
That's the way I put it.
All right. We've got that, I think. Was that your fourth submission?
That was, no, the articulation, my Lord, was the fifth.
Oh, that was 5.
Yeah, 5, that the relevant question whether or not the evidence was adequate for the statutory task is a question of law.
All right, so 6th point.
I've still got a bit more on
Oh, I see.
5, I'm afraid, my Lord.
Sorry.
The judge's approach, we say, is wrong because one looks to paragraph 205, for example, but there's no need to refer to it. It's quite clear from the judgment that he approaches the whole question as a matter of rationality. But we say that that paragraph in particular doesn't squarely deal with our argument. We also say, and it's set out in full in our admission statement, that the judge was wrong to seek to distinguish Hillingdon 1. As I've already indicated, the inspector's task was no different in substance, and the facts were not materially different in relation to the statutory task to be carried out. The only issue for the court is whether there was adequate information, not whether there's none or some. And the question of adequacy, bound in with the duty, is for this court to determine. The judge doesn't, with respect, acknowledge that the Court of Appeal didn't treat the Secretary's decision as having reached a planning judgment quashed in Wednesday unreasonableness. He doesn't square up to the point that we submitted to him. So the sixth submission under this heading, Lord, is that the evidence was not adequate for the statutory task to be carried out. I've got a number of points to make on these, but I readily accept that your Lordships have the bundle, have looked at it, and will look at it again, so I hope I can be forgiven for not taking your Lordships to every reference, but please indicate if you'd like.
The references are in your skeleton argument.
They are. And
is it helpful just to mention them and then take us to any that you regard as particularly salient?
Right, okay. The first point I'm making under this sixth submission is, and it is important, the paragraph 6 task is not a simple single question of prejudice. It's a point I've made before, and we say that for the purposes of adequacy, one needs to know the baseline for traffic flows. One needs to know peak times for lorry goods vehicles. And one needs to have an impact assessment. And we say, without that information, it is not possible fully and objectively to reach a conclusion about the need for modification or the imposition of conditions. In other words, it's impossible to take the view very broadly, well, do you know what? I think the arrangements need to be mitigated somehow. Second point is the essential information was missing. At deposit stage, of course, that very important first stage where the duty really bites, tabs 3 to 4, no impact assessment, no information on baseline traffic, movements in peak periods, no modelling, nothing. And what was the reason, the court may say, when one looks at that? Well, the first reason is that the context of the application, rather like Hillingdon 1, and the application there, was Mrs. Justice Lang's view of the statutory scheme. And it's quite clear from the written statement, paragraph 2.1.7.4, that HS2 took the view that it needed to do nothing more than meet the requirements of the Planning Forum note. Number 6. It is important to understand that PFN 6 requires information to, I think it's probably a good idea to look at the judgment at paragraph 44. I think it may be important, my lords, for the court to have a copy of the PFN. Mr. Justice Ouseley asked for it, and we provided it, and we've got copies if you'd like to receive it. It is quite important, bear in mind.
Right, well, we'll receive that.
Paragraph 44 of the judgment.
That's correct.
Have you got prints of it now?
Yeah.
Oh, there's nobody there to help you.
Thank you very much.
Thank you.
But it's only a single page.
If you've got any spare.
Yeah.
Now, the judge sets out here what the PFN does ask for.
So, which part of it are we looking at?
You see from the front page it's headed lorry route approvals, and at the bottom, contents of lorry route request for approval. Request for approval of lorry routes will comprise, and then over the page for approval, a list of roads. That was provided, it was I think a single page, a list of the roads. And then for information, that means not part of the proposal, but for information. A covering letter, that's not in the bundle by agreement, it didn't really add anything. A plan showing the routes, I believe that's the plan that was referred to this morning and we handed in a colour copy. And then a written statement, which the court has, which describes the sites, it does that. It describes the works at each site, it does that. And then this provides a summary of the lorry route information from the LTMP, which will include predicted LGV numbers and timings. Now the critical point here is that that is a very high level, general, I say so, rather vague requirement for information. It doesn't specify any depth required to the information on LGV numbers.
Will it tell you the number of lorries during peak hours that are predicted?
It doesn't say that, that's the point.
Yeah, when it says, looking at it as a non-planner, will include predicted LGV numbers and timings. What does that... Reading the words as a matter of English and not knowing anything about planning speak.
What it means, it means very broadly when they're going to be travelling.
Yes,
But what
the numbers and the times.
Yeah, timings. But what we say was necessary and adequate for the evaluation task was to have specific timings at the critical period of the day, peak periods, bearing in mind the nature of the roads. What HS2 said is, oh, hold on, it only says LGV numbers and timings, and here are some daily movements which are notional only.
Right. Forget the notional. I just don't understand what it means yet as a matter of English, and it's my fault and I do apologise. When it says predicted LGV numbers and timings, does that or does that not include a prediction as to the number of LGV movements during peak hours?
No.
Doesn't, right?
What does it mean?
Well, sorry, can I just take that answer back? When I say it doesn't include, well, it doesn't specify it. That's the point.
What does specify mean here then? I don't understand what you say you got, and I don't understand what you say you should have got.
Well, I've said what we've got. HS2 provided daily movements, 550 or 480. What it didn't provide was what we say is necessary for the purposes of the task, peak period movements. It could have done that. It didn't do it. The reason
it provided the total number of daily movements, which is the 480.
That's right.
So that's predicted LGV numbers. What about the timings? Predicted timings. It didn't do it, did it?
The day.
My Lords, if it helps, it's on page 55 in the edition, in the better version of the written statement. It gives the working hours and when the vehicles will be allowed into the site.
55.
Page 55 in the supplementary bundle, but it's the written statement.
Yeah.
The new doc that we sent in this morning.
It's in the bundle, but this is a better copy of it.
So estimated LGV numbers and timing.
And you'll see the working hours are dealt with in the 2.1.75.
Yeah.
So it just gives the daily ones then.
Yes.
Okay. And then the other thing that's referred to in the condition 2, which is access to and from the site from the point of view of safety and free flow, the document that you've just handed up does appear to say that the route management improvement and safety plan will include a summary of measures required to ensure the safety and free flow of traffic.
Yeah.
So they had that, did they?
Well, they had a summary of measures, that's correct.
That's your condition, proposed condition 2, isn't it?
Well, in relation to safety, it would refer to condition 2, and in relation to free flow of traffic, condition 1.
Sorry, you should get.
It's supplementary bundle tab 5. It's what's known by the acronym the ROMIS.
Yes.
Yeah, the route management improvement and safety plan.
Yeah.
And where should we look in the route, the ROMIS?
You'll find a list of the measures at section 3.2 on page 73. It's a table which deals with each of the 5 routes that were the subject of the compendious application for approval, and in relation to each of them you'll see measures are specified for the purposes of managing safe movements of vehicles in and out of the access. That sits alongside the description of the access arrangements, which is included in the written statement itself. You may have seen this already, but I appreciate Mr. Eldon's handed up a cleaner copy, but in tab 4, where you had the tab 4, you had that document originally. Each of the various routes is described in some detail from pages 38 through to 46. Same pagination in the better copy, and each of those descriptions, which effectively walks you from one end of the route to the other. In part of the description, you will find a factual description of the proposed access and egress point for each of the routes in question. As you will appreciate, each of them provides access ultimately to a site compound. Yeah. And so if you read the ROMIS and that section together, you get a sense of where the access and egress points are proposed to be, and you get a sense of the measures, if any, that are proposed in order to ensure that they can operate safely in relation to the admission and the exit of large goods vehicles. That, as I understand it, is the way in which it works.
The real problem then, Mr. Howard Williams, is that what you don't have is the peak hours or a baseline of peak hours traffic to measure it against. That's what you say is missing, really.
Well, it is actually more than that. Very grateful my learned friends taking to the only places where there's any hint of what could be regarded as measures sufficient for the evaluation task. There's that single page, which is quite specific to 1 or 2 locations, and your lordships will read when the chapters are read that it's basically factual of what is currently there, not really telling you what measures are put in place, and certainly nothing to do with the free flow of traffic. The implementation page, which Mr. Mole referred you to, relates to safety only.
That was the question, I think, my lord.
Well, but the relevant box refers to free flow and safety. I wonder whether I'd like to, in this context, take court to the Court of Appeal judgment, paragraph 16 and paragraph 56. And I do this because, of course, Mr. Justice Ouseley placed some significance on the fact that the HS2 had supplied information consistent with the planning forum note. Paragraph 16, admittedly in a slightly different context, but the Court of Appeal was presented with an argument on the planning forum, and it said the role and responsibility of a qualifying authority under the planning memorandum can be summarised authorities participate in a planning forum. It's an important body, enabling qualifying authorities to discuss with HS2 a wide range of relevant matters with the aim of facilitating the approval process. The forum will draw up guidance or notes on a wide variety of technical matters relating to evaluation required under the planning conditions schedule. That's a reference to Schedule 17. And then the other passage to refer the court to here is more referable to the facts, but a similar point is contended by the appellant in this case. There's reference here to the inspector's report in that particular case, and the inspector at paragraph 67 within 56 said the application satisfies the forum notes 1, 2 and 3 with regard to the form of the items submitted for plans and specification approval such as this. The depth of information to be carried out by each item is not made explicit in the notes. However, within the supporting material, in this case the written statement, scope exists for the supply of information reasonably necessary to allow an informed decision to be made. And we make the point here that it's all very well saying that the planning forum notes are met, but when you look at them, there's no depth of what's required. So one can say one's complied with the planning forum notes merely by saying, well, these are the daily figures. And actually that was what HS2 said. If I don't take your lordships to it, but I do ask your lordships to read carefully tab 19, the email correspondence, when we were asking for further information. And broadly, the response from HS2 was, we don't have to supply any more. The matter's been covered in the environmental statement. You've got some notional daily figures, and we've met the requirements of the planning forum note. Their case in that regard persisted through the appeal. And what the point I'm deriving from those two paragraphs is twofold. One is, it didn't matter to the Court of Appeal's judgment in Hillingdon 1 that the planning forum notes had been met in that case. And the reason is, akin to the inspector's comments, is that actually that shouldn't be regarded as some sort of comprehensive document, that once you've met it, you've met adequacy, which is, with respect, what the judge concluded in effect. There's still a question of adequacy that stands firm and separate, notwithstanding compliance with the planning forum notes. Indeed, this authority would find it very difficult if one could find that ticking that box simply because one put one set of time, that one said, that's it, you don't have to do any more. 550 large good vehicles per day in the middle of Hillingdon. One only has to stand back and ask, is that really adequate for the purposes of the task under paragraph 6 to determine whether there should be some mitigation? Whether it's rationality or adequacy as a question of law, we say the answer is obvious. And indeed, the Council's decision was rooted in the concern about adequacy. And the point that I want to make here is that what the learned judge did in his judgment was, we say, mischaracterise the case presented by Hounslow, Hillingdon, which was not that we wanted to impose conditions and controls for the sake of it. What was driving and what was the rationale for the conditions was the lack of adequate information. And if I could give you just the key references, the report.
You mean the decision letter?
No, sir. No, my lord. The report to the committee.
All right.
It's at tab 2. Right. And the summary at page 7 of that document, to which the learned judge referred, but doesn't draw from it the right conclusions about the rationale and the driver for our case on the appeal. There on page 7 we say there is no information on how the large vehicles will be managed to reduce impacts. In addition, the Council has not been provided with an understanding of how there's an intention to monitor. No information to indicate, I won't read it, it's there for your lordships to read. In particular, if your lordships will read pages 17 to 18 of the document, which was the engineer's view about the matter, in particular page 18, where the engineer says, without this information, and given that this borough has not been party to the aforementioned traffic assignment modelling process, it's not possible to make an informed decision on the acceptability or otherwise of endgame impacts at this most crucial morning and afternoon early traffic period time. Critically, what's missing from the submission is the reference to how the proposal would impact during peak periods, with a timeline distribution of operational movements. And what's clear from that is not that the rationale was to control, not so much that, not that. What was underlying the concern was that the authority didn't have enough information to do the job under paragraph 6. It needed that information. And that is reflected in the reason for refusal in tab 1. On page 2 of the supplementary bundle, which before it identifies the conditions, indicates in...
Sorry, the reference again, I do apologise.
no, not at all, no, page 2.
Of
Tab 1.
tab 1.
Tab 1 in the supplementary bundle.
Yeah.
The third paragraph. HS2 has failed to submit information in support of the application as to how this proposal would impact during traffic peak periods and how the impact would be assessed via a comprehensive monitoring and reporting scheme. Tying that together with the report and indeed the minutes, which are also provided in the supplementary bundle, one can easily appreciate, we say, that actually the concern of the authority was that it didn't have enough information to carry out its task. But in the context of the Hillingdon 1 High Court judgment, where it considered that actually it didn't have, HS2 didn't have a duty, and according to Mrs. Justice Lang, the onus was on the authority to provide evidence, it said to the inspector, we haven't got that information, but in order to mitigate our concern, we want through this condition to establish a scheme whereby the information can come forward, in effect, putting off the evaluation stage to a condition. But that was the position it felt forced to be in. And that's explained by the borough solicitor in particular at page 24 of the bundle. That's another reference for your note. So we say the learned judge, notwithstanding the thorough way in which he sought to approach the facts, didn't really grapple with our underlying concern about the lack of information. And he proceeds on the basis that Hillingdon wanted information to impose controls. No, it wanted information which it regarded as essential to determine the paragraph 6 question about mitigation, because it didn't have enough to do it without the information. It didn't have enough without any peak hour movements, and so on. If I may say so, Mr. Mole's skeleton argument comes closer to a more fair understanding of our position. It's a paragraph 6 of Mr. Mole's skeleton, where half of the particular sentence is correct, but not reflected in the judgment. In the 5th line of paragraph 6, it was the appellant's position that it lacked the necessary detailed information to judge those matters. Those matters being the matters referred to above, referable to paragraph 6. Now, at the appeal stage, nothing more of substance came from HS2. It persisted in its position, but reinforced it by reference to the legal test, the authority, therefore, was in a position where, in response, it further explained why the essential information was missing. The important references there, my lord, are 1.1.5 to 1.1.6. That's the introduction, and section 7. And they make it clear, along with other paragraphs, that the authority's underlying concern was they didn't have enough information to do the task themselves. So they had no recourse, they thought at the time, but to allow the Secretary of State to be seized of the matter. And because of the nature of Hillingdon 1, they understood that they had to put forward some condition under the paragraph to deal with the point. Now, the response from HS2, tab 16, is important, not least because it stressed the legal test. It might be worth turning this document up. It's tab 16. And I've already referred, and don't need to refer to it again, to section 2. There's the repetition and re-emphasis of the legal test and the burden of proof. But I want now to refer you to 2 points. First of all, at paragraph 3.6. Sorry, 3.5.
2.5.
You'll see at 3.3 there's reference to the environmental statement and the TfL report, which of course was provided to the inspector as the only evidence available for the authority to even begin to consider its position. And at 3.4, as demonstrated in this section of the response, none of these documents provide evidence to demonstrate that the number of movements envisaged in the present submission would have a prejudicial effect on traffic flow. So the case here by HS2 was actually, you don't get anything from looking from the environmental statement or the TfL document. And one can see that repeated in section, in the next section under environmental statement. 3.9 doesn't demonstrate or provide evidence for the Council's contention that the much lower level now proposed in the submission would also have a prejudicial effect on traffic flow. Doesn't demonstrate the submission ought to be modified. But just pausing there, if that's taken away, there's nothing about impact. So what did HS2 say about the TfL report? Well, paragraph 3.31, having looked at the TfL report, it told the inspector, in these circumstances...
Sorry, 3.31.
3.31, my lord, at page 279 of the bundle.
Yeah.
Having looked at the conclusions of the TfL report, HS2 said to the inspector, the conclusions as to the impact of these lorry goods vehicles' movements on traffic flow in the local area are simply not relevant or material to the present appeal. And this has been our position throughout, and indeed it has. And that's really reflected, my lord, in the inspector's treatment of those two matters, where, following what HS2 said, the inspector concluded that they didn't help him, they didn't provide the evidence he needed. He articulated the point by reference to his burden of proof.
So where are we in the decision?
Paragraph 34 and 35 are the burden of proof.
Yeah.
Paragraph 44, I beg your pardon.
44.
He expressed his findings by reference to his burden, and as I shall point out, in complete reliance on the EMRs. And the last part of 44, the original ES and additional Division 2 conclusions cannot, in my view, be relied upon as evidence that the use of the lorry routes as now proposed would, as opposed to might, result in a prejudicial effect. That's to articulate it in the sense of a burden of proof point, but actually, tacitly, he's saying they don't help me. They're not relevant. Can't judge because the figure works are different. And your lordships will appreciate that the mere fact that traffic flows are less in one document to those in another document doesn't mean that there's no prejudicial effect from the lower figure. One still is duty bound to look at the impacts of a lower figure. And the inspector didn't make any findings on that. And in relation to TfL report, similar submissions, paragraph 53 to 54, and at the end of 53, accordingly, I find that the TfL report does not provide clear evidence that the use of the lorry routes as now envisaged would result in prejudicial effects alleged by the council. So again, he's borrowing from his legal central test approach, putting the burden all on the council, and saying, in the absence of other evidence, I conclude that the council has not demonstrated that the proposed arrangements with regard to the routing would have a prejudicial effect. And then this last sentence.
Which paragraph are you in now, sorry?
I beg your pardon, my lord. 54.
Thank you.
And
Yes.
then the last sentence, there is accordingly no justification for the refusal of the application on this ground. So with his burden of proof approach, and whilst tacitly accepting that the information that he did have available was not sufficient to demonstrate anything that was material to his evaluation task, he then said, I am therefore have no option but to grant approval. That's how he understood the statutory scheme. And he did the same in relation to condition 1 and condition 2, the references being paragraph 63 and 81 respectively. In short, he didn't and could not carry out the evaluative assessment that he was duty bound to attempt to do. One stands back and asks the question, having read the decision letter with great respect to the learned judge, well, what was the inspector's finding about what the movements were going to be in the peak hours? What were his views about the baseline traffic, which he said wasn't really a matter for him to go and look at? What were his views about what the impact would be, not just in peak hours, but at particular junctions?
So the paragraph you've shown is up to 57. You could almost fairly summarise it saying these other documents showed a problem at higher levels, but this document is lower, therefore I can't assume that there's a problem, but you say yes, and therefore we need to know whether there is a problem with the lower figure. What about paragraph 58 then?
58
You
is
just
it's a
can't do
similar
that.
point. It's a similar point. These are representations made by local people, as I understand it, referring to the congestion that currently exists, which was not in dispute. We've got a congested area. That's almost axiomatic. And then, and this is where we start to blur into the inspector's next fault about what he regards as the parliamentary intention. As noted earlier, Parliament granted deem permission on the basis of the effects identified in the ES, etc. These both assumed a much higher level of daily movements than the 550 or 480. Whilst I don't reject the concerns, their comments don't constitute the clear evidence required to demonstrate that the proposed lorry arrangements would have a prejudicial effect. A number of faults. One is reference to parliamentary process and what Parliament intended. Two, the fact that he didn't have the adequate information before him. Three, he imposed the burden of proof. and didn't even begin to carry out his evaluative task and didn't make any conclusions about what the impact would be.
I can understand the argument that it's not enough to say 480 isn't a problem, or I can't say if 480 is a problem just by looking at documents that show much higher figures that show there is a problem. I see there's a gap missing then. But I do then wonder whether this comes back to your argument that you simply can't assess whether you ought to modify the arrangements, bearing in mind that Parliament has effectively granted planning permission and assumed that any effect inherent in up to 550 or whatever it was movement was acceptable. And you say you just can't do that.
No, absolutely not.
But I think it almost turns on that, because if he could do that, if he could say, well, Parliament thought that it was all right to grant planning permission with up to 550 movements, this is less, do I think I ought to modify the arrangements further to reduce the impact on traffic? One might say, well, he's entitled to take that view, but you say you can't do that because it's a complete break. Parliament first, separate assessment afterwards.
Yeah. Otherwise, if I may say so, and that's the whole concern of the Council, is that one's eroding the very principles of the Court of Appeal's judgment, is that Parliament intended the local authority to have a democratically answerable role in mitigation of an important matter. And you're right, what the Inspector seems to have done is said, well, I don't need to be too concerned because Parliament's already given its approval to higher figures. Well, that doesn't carry out the task that he was duty-bound to consider by any stretch of the imagination. My Lord, if I may, I'd like to turn to ground 1C. What the Inspector did in circumstances where he didn't actually properly arrive at an evaluative conclusion under paragraph 6, the reasons that I've given, he placed complete reliance on the EMRs, in effect taking away meaningful control from the local planning authority. And we say the Inspector is not entitled to do that, and quite contrary, again, to the principles established in the Court of Appeal's judgment. I've got 5 submissions to make. The judgment purports to consider this issue at paragraphs 215 to 218. The first submission is this: the decision maker is not entitled to leave off to the EMRs matters which require to be considered at the Schedule 17 stage. They are material considerations, but they must not be used to oust the statutory duty or in any way modify or limit it. The reference to that, my Lords, is paragraph 68 to 69. Please note in passing that learned...
Sorry, those numbers again, 58?
68 to 69.
Thank you.
Of
H1.
of the Court of Appeal's judgment.
The Court of Appeal's
Did I
judgment
say page? I beg your pardon. I meant
No,
paragraph.
paragraphs.
is of what?
The Court of Appeal judgment?
Yes.
And basically in Hillingdon 1, yeah.
When you read the judgment, bear in mind that when he looks at the statute, the learned judge doesn't actually look at paragraph 68, and when he comes to make his conclusions, we say there's not an adequate regard or attention to what the Court of Appeal said in paragraph 68. But that's not in dispute, that first submission. The second submission, that the reference in the statutory guidance to avoiding replication and modification is therefore not to be seen as stripping away the authority's control. I emphasise the word control under Schedule 17. And I rely on the Court of Appeal's judgment, paragraph 76, for that submission. Again, I don't believe it's in dispute. The third submission is this: Parliament did not intend that the EMRs were to be used to circumvent the controls under Schedule 17. See in particular Court of Appeal's judgment, paragraphs 81 to 82, and 84 and 85, where it's even more clear what the Court of Appeal was saying about this bespoke statutory scheme. The fourth submission is that the Court of Appeal rightly regarded the EMRs as a set of somewhat loose contractual obligations, I'm borrowing words from the Court of Appeal's judgment as you appreciate, not to be equated with the controls given to local planning authorities. And it might be worthwhile just looking at paragraph 82 of the judgment to appreciate the importance of this particular point.
I'm so sorry, paragraph? 82.
Yeah. Standing back, we ask rhetorically.
That's the one. I won't read it out now, Your Lordship, to look at it.
Can you give me some sense of what the EMR level of detail is? Here, if you read from 68 onwards, HS2 said, trust us, leave it to us. When we get to digging up the archaeological site, if we think there's a problem, we'll let you know and we'll sort it. And that wasn't acceptable. But you said that you can have regard to the environmental minimum requirements. I'm just wondering at the moment, if in fact those say you must do the following if 550 vehicles, and in fact you've got 480 vehicles, so you'll do the following but for a lower number of vehicles, I do wonder whether the EMRs do help, not replace, the assessment of the statutory duty. So it assists me to know, or if there's a document here, what the EMRs actually say that's relevant to this particular issue. Can you follow me?
Take Your Lordship next to that.
Oh,
The
right,
point
okay.
on 82, my Lords, is it's just to have in mind that part of the rationale of the Court of Appeal was not just that you shouldn't strip away the controls of the authority, but you shouldn't strip away the Schedule 17 controls of the authority and give them to HS2.
Yeah.
Which makes it effectively judge in its own cause.
Yeah, well, that's what the court said at the end of 82.
Yeah. Lord, on the EMRs, obviously Your Lordship will appreciate that...
You're submitting, I'm sorry to cut across you, but just to get the essence of what you are submitting to us, you're submitting that by analogy with that scenario, if you like, at the end of 82 of the Court of Appeal's judgment, the present case demonstrates precisely the same mischief.
That's right.
But for that, don't we need to know what the EMRs say?
Yes.
Yeah.
Of course we do. And the background to the EMRs, as Your Lordship would appreciate, that there's the development agreement. It's not providing the bundle. It's common ground that HS2 is contractually bound to them.
Right,
but
yeah.
for that reason, you need to look, well, actually, what do they say? Well, first is the essential one here is the Code of Construction Practice, which is at tab 9. And I hope I can be forgiven for taking the court straight away to the specific chapter. These are extracts provided, and there's a chapter relating to each individual topic. So 14 is the relevant chapter here. And at 14.1.1, it says, during the construction works, the nominated undertaker will require the impacts from construction traffic to be minimised by its contractors where reasonably practicable. So, HS2, of course, where they think it's reasonably practical, either don't need to minimise or minimise they might, but only to an effect which others might judge to be not enough. 14.1.2, the nominated undertaker will require that public access is maintained where reasonably practical. Fourth line, reasonably practicable. Last sentence, the impact of road-based construction traffic will be reduced by implementing and monitoring clear controls on vehicle types hours of site operation, parking routes for large good vehicles, all under the umbrella of the reasonable practicality caveat qualification. So the system of the EMRs is led by HS2. And if one looks over the page, we can see there's a list of matters that are set out there for route-wide measures. They're all governed by 14.2.2 in the preamble. The last line, the RTMP will include as appropriate.
Well, could you read the first sentence?
Yeah, generic measures which will apply route-wide will be discussed in advance with the local highway authorities and other appropriate authorities. Prior to commencement of works, etc., the RTMP will include as appropriate. There's no contention in relation to the local authorities' role, which is a consultative one.
What about 14.2.4, traffic management, local area measures? They've got to be
right.
Produced in consultation with traffic management plans.
Yeah.
And you say it's the same guys because HR2 have got to produce it, because that includes a lot of things like the proposed traffic management strategy, timing of site operations and timing of traffic movements 14.25, and lots of other things.
Yeah, it does. Lots of things, but...
Yeah. But you say it's the same guys because HR2 have to produce it in consultation.
Well,
So,
that's what the
yeah.
Court of Appeal said.
Yes, no, just that I've understood it. It's
Yeah.
not an opportunity to jury play, trying to work it out.
Absolutely. But the
And
whole
you say it's not enough
Yeah.
because it's HR2 driven. And you say Hillingdon says you can't have an HR2 driven thing, you've got to have democratic accountability.
Well, it didn't say you can't have an HR2 driven thing. What it said is that you can't rely on the EMRs to do what should be done at the Schedule 17 stage.
Right, so that I've understood what you're saying. This is wrong because it provides that HR2 of certain things, and Hillingdon says for constitutional reasons that must be done by a democratically accountable local government. That's your submission, is it? Yeah.
And the Court of Appeal put it in rather more stark and stronger terms. And my Lord, on top of 170, the third line, the LTMPs will include as appropriate.
Sorry, which paragraph now?
On page 170, it's
Yes.
in paragraph 14.2.4.
Yep.
And you'll see the LTMPs will include as appropriate. A list of roads and so on. And then 14.2.5, in relation to lorry management, LTMPs will include details of the following where appropriate: timing of site operations and timing of traffic movements. And over the page, site-specific measures are referred to, including timing of traffic management operations. But at the time of the application, the LTMP did nothing more than provide the daily figures.
So the inspector could have regard to these matters in deciding whether he ought to modify the arrangements on the grounds of road safety and highway safety.
Well,
What
not merely could, but
Must.
had to.
Should.
Right.
But
Yeah.
your
Sure,
submission
sure.
is that
Yeah.
even when he has regard to them, by definition, although he's had regard to them in the sense that he's read them and digested them internally, he has to say, but of course, this does not assist me because I must decide whether the number of road movements during peak hours requires that the arrangements ought to be modified.
Yes. And what's happening here is that HS2 said, we don't have to provide anything more than the PFN. There's some broad figures. We're not going to give you an impact assessment, but don't worry. We're going to impose some controls and minimise the effects when we get to the EMR stage. That is root and branch, no different from what happened in Hillingdon 1.
Do they have to approve they have to approve the routes, don't they? And they've approved the routes, and there's no issue about that.
That's correct.
We're just talking about the arrangements with respect to the routes.
Yes. Now, the learned judge doesn't acknowledge that, we say sufficiently at least, the import of the Court of Appeal's views on this important matter. A further point is the reference to the figure of 550, because it shouldn't be left out of account that that figure put forward by HS2 was to fulfil an assurance. The assurance was part of the undertakings to which it was committed, but that assurance as well was subject to HS2's approach on reasonable practicability. And the reference for that is tab 5, page 87. So even the figure of 550 is not one to which HS2 was legally bound under the assurance. Legally binding affected.
Sorry, tab 5, page 87.
Tab 5, page 87.
And where are we looking there?
And you'll see at the top of the page, this is a list of undertakings. Subject to the conditions set out in paragraph 6.4, HS2 will use reasonable endeavours to attain a maximum of 550 per day, or fewer if the measures below permit, at Swakely's roundabout, and reduce, so far as reasonably practical, the number of HGV movements at the roundabout. And then if you'll cast your eye down to 6.4...
But sorry, just to capture the point there, that the operative words are use reasonable endeavours.
And so far as it's reasonably practicable.
Yeah, but that governs something else, doesn't it?
Well, it covers the reduction, which is aimed for in the peak hours.
Yeah, at Swakely's.
Yeah. And further down at 6.4, the assurance is given in 6.1 and 6.2 are subject to the following conditions as appropriate. The measures being reasonably practicable, having regard to any material adverse impact on the safe, timely, economic construction of the HS2 works. Any material adverse impact on delivery. Any material adverse impact. And the similar at 6.5. In HS2's limited consideration of whether the measures referred to in clause 641 are reasonably practical, having regard to any material adverse impact, HS2 will have regard to any associated benefit in the reduction of HGV movements or the reduction in sustainable placement. So,
Sorry, you've just been at 80, which page were you on then?
87,
Bottom of the page.
Bottom of the
yeah,
page, yeah.
I'm turning over to the top. And your lordships can read the assurances, and they're littered with that caveat, which it not only shows that HS2 lead the EMRs with the local authority not having any direct control, but it is also caveated so that the use of the word committed, obliged, controls is not really a very accurate one, insofar as it's really up to HS2 to decide what it should do, if anything. So I'm not even sure it's actually right to refer to the system as a control. So nowhere does the judge grapple with this particular point. And I think the references that I'd like to take your lordships to in the decision letter, first of all, paragraph 26. Where there's a reference to the LTMPs, and there's a reference to a statement made on behalf of the government in Parliament.
I'm sorry. Which paragraph in the decision letter?
26.
26.
26, yeah.
Sorry, we're jumping around and
I know.
bundle
Sorry.
fatigue sets in the end.
Um,
Albions.
Third line, on my reading of Mr. Miller's statement, he was advising that the information as to what vehicles were going, where and what restrictions were to be applied on the roads would come through the local transport management plans as being the vehicles through which the extra detail relating to the management of construction traffic would be provided. What actually he seems to be saying there is that actually my understanding of what's happening here is that this is to be dealt with under the EMRs. Now, the learned judge says, well, he may have used the wrong language, but actually he meant something else. But I don't think that's a fair reflection of the decision letter itself. Look also at 76. Actually, I beg your pardon, my lord, I do apologise. 65. Maybe better if I just list these references. 65, where there's reference there following the High Court's judgment. The correct approach is for the application to be determined on the basis that any requirements of the EMRs will be applied by HS2. It's not the role of the Schedule 17 planning process to seek to enforce controls within the EMRs by withholding approval.
Before we get to that, can you just help me also on some other paragraphs that I'm puzzling about? This is page 266, proposed condition 1, paragraph 59, and it says the main purpose is to limit the number of LG movements on specific parts of the network at peak times. And that seems to be a fair reflection of proposed condition 1. One can argue about it, but assume for the moment that's fair. Then at 62, the council says there would be an uneven spread of the 480 daily movements, resulting in elevated levels in the peak hours. And then the inspector says he's satisfied that that is based on a misunderstanding of the data, but that HS2 accepts there would be a slightly higher flow than the hourly average in the evening peak hour. This does not on its own serve as evidence of a prejudicial effect. And the inspector says on this basis alone, proposed condition 1 does not satisfy the paragraph 6 requirement that they be imposed only on the ground that the arrangements ought to be modified. There is no clear evidence that the number of movements now envisaged would have such a prejudicial effect as to require the proposed routing arrangements to be modified in the way that the council suggests. Reading that in isolation, that seems to be looking at the figures, 480, likely to be slightly elevated, but not unduly dreadful in the inspector's view. And for that reason only, you would think there wouldn't be a need to modify the arrangements. And I wonder whether, despite all the criticisms one makes or can make of the decision, whether that isn't his core finding on traffic movements in peak hours.
Well, I think I don't want to repeat our submissions, but we don't accept that the decision letter, and in particular these paragraphs, even if you were to put the rest to one side, which you can't, you have to read it in context, that he is approaching it on the wrong basis. He's dismissing evidence that he doesn't accept is going to be what will happen, but he doesn't know what is going to be happening. So he's got no basis to carry out the task that he's set for him under paragraph 6.
If he has to have detailed knowledge of precise numbers, as opposed to what he seems to have based his view on, 480 a day. Of those 480, there'll be slightly more in the evening hours.
Well, I think we do say that it's absolutely critical that he has a figure, because if you remember, for the 480 figure, it's just set out as a notional figure. It doesn't relate to individual sites or particular times. It's what HS2 regarded as a crude aggregation. So that's all that was there in relation to travel during the peak periods. But he had no basis to judge the impact of it. But nothing. What he had was the ES and the TFL report, which he said didn't help me.
But those don't help him tell the figures, because the figures are lower and he needs to know whether the 480 creates a problem that leads to the need to modify the arrangement. And just look at these paragraphs in the abstract. He seems to be saying, I hear what you say, but he hasn't got enough data. But he seems to be saying that he's accepted arguments and data that shows there'll be slightly more per hour in the peak hours. You can't just average it out over the day. And he doesn't think that's enough.
Well,
But you say that's not sufficient.
well, it isn't. And what he actually says, my lord, is it doesn't on its own serve as evidence of a prejudicial effect. That's again to borrow from his burden of proof approach. It's not to reach a judgment by himself. He eschews that. So 76 is another example where we say that the inspector was in effect just looking to the EMRs for what actually should have been part of his task. And you'll note that at the end of 76, in the middle there, I consider that in proposing this requirement, this is condition 1, the Council is seeking to use the Schedule 17 process as a means of policing, monitoring and management arrangements in the EMRs. That's not the purpose of Schedule 17 application and approval process. And I think it might in that context be helpful to look to what learned judge said on that particular issue, on this particular issue. One looks to paragraph 213 and 214. I'll allow your lordship's time to look through those.
What's the evidence he's referring to at the beginning of 214, including that from LBH, which it said proved its case, that the conditions have been made out?
That the conditions.
What's the evidence he's referring to?
I think that's the ES and the TFL, which we relied on in the circumstances that I've indicated to indicate a prima facie case of prejudice, of harmful effects.
Is there a summary anywhere in the papers before us of the Council's evidence? That's to say the main elements of it. Do we have that anywhere? In the skeleton arguments or anywhere else?
Well, paragraphs 11 and 12 of our permission skeleton may assist your lordships. Otherwise, it's the local planning authority's response statement on appeal, which is in the bundle.
Would it be possible, I don't know whether it would, over the short adjournment, just to let us have, as it were, a brief note of where we can find the salient parts of the Council's evidence, in particular relating to the need for the conditions?
My Lord, if it assists in advance, it is clear, particularly from paragraph 36 of the Inspector's decision letter, that the Council was relying upon what it said was a clear position from HS2's evidence. Paragraph 36, and that will be reflected if you look at the minutes of the committee, Council's statement of the case, and its reason for refusal, and Mr. Mould and I, well, Mr. Mould will, and I will, if he doesn't, take you to those relevant passages. But the Hillingdon was saying there was sufficient evidence from HS2 to warrant the imposition of the conditions. That formulation seems rather to have been overlooked in the way that council formulates its case.
Well, we'll no doubt come back to that.
I've already made my submission on the particular point Mr. Elvin has sought to make, which is that the inspector and the judge didn't grapple with the rationale for the condition, mischaracterised our case. It was quite clear from the documents to which I've already made reference that what underlied our refusal was inadequate information. I've already pointed to those documents.
Yes, but when it went on appeal, what we're getting at is what the council's case actually was in substance on appeal. I mean,
Yeah.
there are two stages to this. Obviously, the first stage when the council had the matter before it and took the decision it did, but
Yeah.
then the appeal when it had a chance to reflect on what it should provide to the inspector.
My lord, it's pages 207 to 211 in the supplementary bundle. That sets out the council's court case in relation to the two things.
Well, let's just, if you don't mind, we'll just have a quick look at that.
I'm sorry, was it 207 to
207 to 211.
Thank you.
Yeah.
And this is in which document?
It's the
Statement of
council's
case.
case to the inspector behind tab 11.
Thank you.
It's couched as being, it's headed HS2 Ltd's response to the conditions, and obviously the logic is that the council are saying this is why, in response to HS2's case as appellant, this is why the conditions are required.
But the evidence before the inspector, as opposed to the evidence that, in particular, the council relied on for making its case, seems to have included more than these two documents, the ES and the Transport for London document, because by definition I thought the submission document was the one that produced the 480 lorry movements, and there must have been something on top of the other material. So whilst the council may have been relying on two particular documents, in terms of my law's question, there must have been other documents or other material identifying the 480 movements.
The 480 movements were identified in the written statement that was submitted in support of the application for approval.
Yeah.
They
They must have said, have they got that, didn't they? They can't have said, we've
yes,
not got
they
a
do.
new
It
number.
was derived. It was based. Those were the predicted lorry traffic generated in relation to each work site. The aggregation of the daily movements, which were predicted in the draft local traffic management plan.
Right.
And it says as much in the written statement itself.
Right. So the inspector had the TfL document, the ES document, and the calculations put in the appellant's statement.
Yes. He had the LTMP in front of him. You don't have it, I'm afraid. Oh, you do. You do have it.
Oh,
Yes.
do I need it?
Yeah.
Oh, please, no.
Mr. Elvin, I think,
Right.
is going to say.
What I'm going to suggest, if I may, is that we can give you a little longer to make it possible to do it comfortably, is that the three of you can agree, please, over the adjournment, if possible, this adjournment, what the constituent parts were of the council's evidence on the appeal and where we can find them in the bundles. Forgive me for requesting that, but when we're taken to paragraph 214 of the judge's judgment and we see him referring to the evidence including that from LBH, which it said proved its case, we need to know what he was referring to. So that exercise, I think, is essential.
And I wonder whether I just wonder whether it would be permissible if I provided you with the relevant references to what our case was.
Yes. Well, no, of course it would.
I mean,
But it'd be nice to have it agreed as well.
well, do you know what? I'm not sure we're going to achieve that.
Oh,
I can give you the
Inspector had
references
more than
now.
what you said. You said these two documents, as I understand it, prove there's a problem, and that's why you wanted further information. But I haven't seen this LTMP or the appellant statement, and that appears to be telling the inspector, don't worry about it. It's 480, not 550. It's not all equal, but there's not going to be that much more in the peak hours. So, although you like certain documents, the inspector might have liked other ones.
There's no other document that isn't in the agreed bundle that your lordships need to see.
Right, so the appeal
figure-
statement is
the
in there, is there, that we
The
just haven't
figures,
focused on?
the figures that have been referred to in terms of movements were taken are taken from the current LTMP.
Yeah,
But the LTMP is not before it because nothing else matters in that document.
right.
But they're borrowed from it. They only provide what we called, and HS2 called, notional daily figures. That's it.
Yeah.
All right, well, look, what...
Other than that,
Mr.
just
Williams,
if it helps,
sorry, I'm so
they just
sorry.
had the ES and the TFL report.
If I may, we're going to stop until 2 o'clock now. If you'd like to produce your schedule or list of the constituent parts of the council's evidence of appeal, that will help us. If your opponents can see that and have the opportunity of deciding whether they agree with it, that would be even better. And better still than that would be that you all three produce an agreed document. But I appreciate there may be difficulties in that. Let's hope. So we'll come back at 2 o'clock, and at which stage we'll take stock of progress. 2 o'clock then.